jury selection continued today for the second day in the murder trial of Karen Read. She is accused of killing her boyfriend, Boston police officer John O'Keefe, back in 2022.
So joining us to give us some insight on today's developments is former Massachusetts Attorney General Martha Coakley, who's now counsel of Foley Hoag LLP. Martha, good to see you.
Hey, Martha.
Hi,
It's
Jessica.
great to see
Hi,
you.
Ed.
Very good to see you as always. Now, as we reported, seven were chosen today. 4 were chosen yesterday. Obviously, it's so far a total of 11. As we go into the third day of jury selection tomorrow, I'm curious, I don't know if there's such a thing as a typical murder trial, but is this on pace for a typical murder trial, or is this moving slower?
I actually think it's moving relatively quickly for a high-profile case. That's one of the issues, obviously, in selecting jurors. But you now have 11 jurors. The judge will look to seat 16 or 18 to make sure she has enough alternates. You could have a jury at this pace by tomorrow. So I actually think it's pretty much on pace and actually moving quickly for a case that's had this much pretrial publicity.
In a timing for the case too, Martha, if they do select the jury, for example, tomorrow, would they begin on Friday or would they begin arguments on Monday? What do you think, just schedule-wise?
It's totally up to the judge, and I think sometimes people are anxious to get started. I don't think she will start unless both sides can get their openings in. So it's hard to know, but I think if they're complete tomorrow, they may be ready to go with openings, both sides, on Friday.
Got it.
Okay, so let's go a little bit backwards here, because we know 85 people were brought in for questioning as part of today's jury pool. The judge and the lawyers were interviewing them one by one in private, but they were also asked to fill out a questionnaire, answering questions we know, like if they've heard about the case, if they've already formed an opinion about the case. Most said they've heard about it in some way. We know more than a quarter say they've already formed an opinion. So in your opinion, what do those answers say to you about how this is going for both the prosecution and the defense?
Well, of course, they don't ask which side they've made their mind up about. So I think that's also pretty typical, because I've had the opportunity and I've watched high-profile cases. We would be surprised if people hadn't heard of the case. But the key question is, have you already made up your mind? As we found in the national trial with Donald Trump, everybody is going to have heard about him. The question is, have they already made up their mind? And that's what the judge's job is, to keep any opinions before people hear the evidence and then be able to deliberate together to get a verdict.
And Martha, there's also a legal fight outside of the courtroom. An SJC justice just today upheld a buffer zone that the judge put in place to keep protesters 200 feet away from the courthouse. This could be appealed to the full SJC. So I'm curious, in your legal opinion, do the protesters have a case here?
I think that the judge made a fairly smart and balanced decision. That's what we're talking about here, balancing defendants' fair rights, the Commonwealth's rights, the rights of the victims, the witnesses to come in. And the single justice also said he found that the judge's order was narrowly tailored. Those are the magic words in some ways for this kind of a restraint on speech. First Amendment's not unlimited. This judge and the Supreme Court are going to want to make sure that both sides get a fair trial. And that's why we have the questionnaires. That's why everything that those jurors are going to hear should be heard in the courtroom. And that's part of what this buffer zone is about.
Got it. Martha, thank you so much. Great to see you.
Thank you, Martha.
Have a good night.
Take care.